All right. Good evening, everybody. Thank you for joining us for Wills Week 2025. This is the opening day of our week-long initiative that has several different topics throughout the week, held both virtually and in person. So very happy that you could join us tonight. This is our first virtual session of the initiative this week. So happy that you could be here. Just to give you a little bit of a sense of what to expect tonight, I'll go through a quick little introduction before we turn it over to our presenting lawyer, Anna Mae Choles. So thank you very much again for joining us today for Wills Week and this Wills and Estates 101 session. My name is Matt Mandrusiak. I am the Manager of Philanthropy with the Edmonton Community Foundation, and I am your host for tonight's webinar. Thanks to an amazing group of volunteer lawyers and tax professionals, this year's Wills Week offers 9 presentations, both in person and online, to inspire, guide you in proper preparation of your estate plans. These plans include not only a will to protect your family, your business, and your assets, but also 2 additional documents to help you during your lifetime, should you temporarily or permanently lose your independence. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide Wills Week as an important resource for Alberta-based will and estate information. It unites our role as a trusted partner to help people create a legacy for their community. Our area of expertise is endowment funds, contributions that are invested and provide ongoing support to enhance our community during and after our lifetimes. To learn how these funds are affordable options and how you can help you save taxes, please visit our website, www.ecf.ca. In our work, we see a lot of wills and understand how powerful these documents can be. We want everyone to benefit from these Wills Week sessions and understand how professionals can make your will more effective and accurate. If you have any questions for Anna Mae during tonight's presentation, I encourage you to please type them into the Q&A box that you'll find. We will be answering questions at the end of the presentation, but I should also let you know that we do have quite a few folks that are registered for tonight. So if you do ask a question, we may not have the ability to get to your specific question, time permitting, of course. That said, we will try and answer as many as we can, and do ask that you try and keep these somewhat general, as we do want the answers that Anna Mae will provide to benefit everybody who will be on the presentation tonight. And just as a note of follow-up, we will be hosting a total Q&A session with 2 lawyers to end Wills Week on Friday. So for those of you who may have questions that come up throughout the week, or maybe asked questions and didn't have the opportunity to have them answered, I encourage you to look on our website, ecf.ca, and sign up for that virtual Q&A session Friday morning at 10. And I'll also advise you that these presentations virtually will be recorded and made available on our website, ecf.ca, shortly after Wills Week wraps up. So within the next week or 2, we should have all of these virtual sessions posted for you to come back to, review, and share with those who might be interested in learning a little bit more. And finally, before I introduce Anna Mae, I will state that we do have a survey that we would love for you to fill out at the end of this presentation. When you click end session, or when you leave, a survey link will pop up. I ask that you do please take a minute or 2 to fill that out. It's only a few questions long, but it helps us know that what people want to see from these events. And our goal as an organization and the lawyers who are presenting these sessions really want to make this worthwhile. So your feedback really does help us to make sure that we're putting something forward that's worthwhile to the public who is attending. And now, without further ado, I would like to introduce our presenting lawyer tonight, Anna Mae Choles. And following an undergraduate degree in honors political science at the University of Alberta, Anna May earned an LLB in 2011 from the same institution. As a law student, Anna May gained critical legal research and analysis skills by working as a student researcher for the Centre for Constitutional Studies and the Alberta Law Reform Institute. During this period, she complemented her studies by volunteering at Student Legal Services in the Civil and Family Division and the Edmonton Kids in the Court program and the Golden Key Honor Society as a mentor for the English Key program. Since being called to the Alberta Bar in 2012, Anna May has gained comprehensive experience in advising clients in various legal areas, wills and estates, real estate, commercial, and corporate commercial law. She continues to remain active in both legal and broader communities and serves as co-chair for the Elder Law section for the Canadian Bar Association Alberta North, is a volunteer for Junior Achievement, and is a member of the Society of Trust and Estate Practitioners and has the designation of TEP, Trust and Estate Practitioner. She's also a regular presenter with us, the Edmonton Community Foundation, during our Wills Week initiatives, and we certainly appreciate her help and her expertise. In her spare time, Anna May enjoys ultimate frisbee and hiking. And so I'm going to turn it over to you, Anna May. Feel free to share your screen. I'm going to turn off my camera, but we'll monitor the Q&A, and I'll be back in a little bit to help guide some of those questions. So take it away.
All right. Thank you very much, Matt. As Matt said, my name is Anna May Choles, and I am a lawyer with Racklin Company LLP here in Edmonton. And the presentation we're going to be looking at today is called Wills 101. All right, so we're going to start off with a bit of disclaimer. When we're presenting public presentations like this, lawyers always like to clarify the information we're presenting. This is legal information. This is not legal advice. Legal advice is specific to your situation. This is about information about wills and the various legal impacts of other documents. You need to retain your own lawyer to obtain your own independent legal advice and not simply rely on the information provided in this presentation. All right, so in this presentation, what are we going to be looking at? Well, we've got quite a variety of topics that we're going to be taking a look at. And first off, we're going to be covering what a will is. Then we need to talk about why it's important to make a will. Now, a will deals with your estate, so we need to cover what we mean when we talk about your estate, what a personal representative is, what their role is. Other things to consider when you're making a will, such as who will care for your children. We're going to talk about the way you would distribute an estate and the types of gifts you can give under a will. We're going to briefly cover some tax concerns, although I note I am not a tax lawyer. I am not an accountant. I have basic information about how taxes can impact an estate. But later on this week, I believe Thursday, we do have an accountant, Michelle Coleman from MNP, who's going to be doing a presentation all about estate taxes. So if you have a specific tax questions, that's an excellent presentation to attend. And that's going to get far more into depth. I'm just going to do a brief overview. We're also going to talk about different types of trusts you can set up in a will for children, for adults. And then I've got a couple of general will questions that commonly come up that I like to just sort of cover right away, because that covers off a couple of areas that people often have questions about. So the other thing I like to do when we start a presentation is to cover off some definitions. Unfortunately, legal work, and particularly the wills and estates field, tends to have a lot of jargon, a lot of very specific terms. A term got defined back a long time ago in the court system, and we keep using it now. So we want to make sure that you understand what I'm talking about. We're just going to quickly cover off some of those definitions. So first off, we have an Alberta specific term, and that's adult interdependent partner or adult interdependent partnership. So that is commonly the Alberta term for common law. We don't otherwise have a legal authority on the term common law, but when we're talking about an adult interdependent partner, we mean a person that you or the deceased have lived with together for a period of a minimum of 3 years, or you've lived with and had a child with, or you have signed an agreement to be an adult interdependent partners. So that's what we mean. It's a very specific term. When we use the term beneficiary, that means typically in this presentation, it's going to be a person who inherits or receives a gift in a will. It can also be a person who is named to be the beneficiary of a very specific asset that falls outside of the estate that someone receives on the death of a third party. The term estate, we're going to get into more details as to what we mean by estate and what assets are included or excluded from an estate. But at the very beginning, just so that you understand, when we use the term estate, I'm meaning all of the assets of a deceased that are distributed under their will. Personal representative, again, this is another Alberta specific term, and that refers generally to the person who is in charge of the estate. Sometimes this person is also called an executor or an administrator, depending on the circumstances, but personal representative covers both of those categories, and it means the person who's in charge of the estate, and they would get the court order and they'd have the legal authority to make decisions on behalf of the estate. Probate, one of the most common questions I have as a wills and estates lawyer is, what is probate? And at its basic level, probate is the process by which we prove a will to be valid through the courts. And then at the end, once you've proven that will to be valid, you have a grant of probate. And then that's what you take to the banks and use from there on out. But probate is that process. Next, intestate. This is a bit of when we're getting onto more of those old school jargony terms, but intestate is a term that means a person who died without a will. Therefore, testate means a person who died with a will. So if you had a will when you died, you are said to have been testate. If you didn't have a will when you died, you're said to have been intestate. And therefore, the person who writes the will is called the testator. Then lastly, we have the concept of trustees. So a trustee is a person who administers a trust set up under the will. And at the end, later on in the presentation, we'll go into some more detail about the types of trusts that we can have under wills. All right, so let's start off at the beginning. What is a will? Well, a will is a document that sets out how and to whom you want your assets to be distributed upon your death. And a will critically does two major things. You always want to have an appointment of a personal representative. You're always going to appoint an executor in your will to say, this, when I die, here's who's in charge. This is the person who I want making decisions. And then secondly, a will distributes the assets of the estate. So that gives gifts, money, personal property, real property, or land. A will sets out what's going to happen with your assets when you die. So we've got the appointment of the personal representative and then the distribution of the estates are the two main elements of under a will, although wills can also do a couple of other things. Now, one of the things I always like to address when we're talking about a will is what a will cannot do. So a will is of no force and effect until you are dead. It is of no force and effect during your lifetime. Your executor doesn't have any authority, or your personal representative does not have any authority until we've got a death certificate. That means if you lose the ability to make decisions during your lifetime, the will cannot be used in that circumstance. Rather, there's two separate documents that we require. If someone is in a coma, if they suffer a head injury, if they get Alzheimer's or dementia, there are two other documents that each of you need to have to make sure that your estate is properly taken care of. And that is an enduring power of attorney and a personal directive. Now, an enduring power of attorney is a document under which you appoint someone to make financial and property-based decisions for you. So that's one document. That person, and under that document, they only have the authority to make decisions about your finances. They file taxes, they can buy and sell land, they can do all of that stuff, but it's only property and financial decisions. The personal directive is all the other decisions. It's all the decisions of a personal nature that do not relate to your estate. Primarily, we're talking the big ones are healthcare and residence. So healthcare and where you're going to live. Now, there's an element to which these two documents interact with each other. If you've got someone who's got dementia and the person under the personal directive, who's called an agent, if the agent under a personal directive is making decisions about where they're going to live, but the attorney under the power of attorney is making decisions about paying bills, well, they have to work together to make sure that the bills of that person are paid, especially if we're talking about needing to go into residential care or get home care or anything like that. So the two individuals in these documents, who can be the same person but don't have to be, there is an element where they have to work together. But importantly, you do need both of these documents because the will cannot cover this area. So if you've got information about this in your will, that's not helpful. You need to have the enduring power of attorney and the personal directive as well as a will in order to have a fulsome estate plan. All right, so let's talk about why you would want to make a will. Well, a will distributes your assets after your death. That means you get to make the decisions as to where your money and assets are going to go. You get to decide who's going to be in charge of your estate, who's going to control your assets, and who you think is responsible enough to manage that responsibility. If you have minor children, you can name guardians for your children in your will. You can also set up provisions to make sure any minor children you have are properly supported after your death. You can deal with any children or other family members who might have disabilities and making sure that they're properly taken care of after your death. You can give consideration to things like, well, how old should someone be before they actually receive money from my estate? Is 18 old enough, or should they be older? And then you can put in trusts in place to help manage that. If you have specific business or farm interests, you can use your will to deal with some succession planning. And I believe we also have another presentation that I'm sure Matt will mention later on, specifically addressing small business planning in an estate context. So that's always a good thing to think about. We could also do some tax planning in your will. You consider the tax impacts of various assets that you have and how best to manage that within your estate. You can give gifts to charities in your will. You can, and that could be part of your estate plan to say, okay, I know I'm going to have so much tax, but if I give some money to charities, that will give me tax credits that I can use to decrease the amount of tax my estate has to pay. And you could also use this to simplify the administration of your estate, to think, how can I make things simpler and avoid possible conflicts that might arise between my various family or friends regarding my estate? So that's what a will can do. But what happens if you don't make a will? Well, there's legislation to address that. The government of Alberta has put in place a document called the Wills and Succession Act. Now, the Wills and Succession Act deals with wills, but it also deals with what happens if you don't have a will. And so we said before that when you die without a will, you're said to have died intestate. So you're a person without a will. Well, the intestate succession provisions of the Wills and Estates Act, of the Wills and Succession Act, deals with that situation. So that means you don't have any control over who your personal representative is going to be. And that can make administering your estate more complicated. When you have a will, your administrator or your personal representative or executor can take that document to a bank and say, this document says I'm in charge. There's information that I need to deal with my estate. The bank can look at it and say, yeah, this does say that you're in charge. Okay, we can give you this information. When you don't have a will, it's a lot harder for the banks to know, well, who is in fact supposed to be in charge? So, but the most important thing is that you're not making that decision. Under the Estate Administration Act, there's a list of priorities as to if someone doesn't have a will, who has the priority to apply to administer their estate, their intestate estate. So it presumes spouse or adult interdependent partner first, and then adult children. And then after that, if you have minor children, then actually it would be the public trustee's office who's the next priority. And after that, it's potentially your parents. There's a whole list of it, but it's not the person you chose. And that may end up meaning that someone who you wouldn't want to manage your estate would be the person managing your estate. The next thing you don't have control over is the distribution of your estate. You can't say specific things go to specific people. You can't say who should receive money and who shouldn't, because the legislation assumes certain things. Particularly, this is a problem for second or third relationships, or where you might have multiple children from different relationships, or stepchildren that you want to make sure are inheriting. Or perhaps you have some informal adoptions in your family where there isn't legal paperwork. Those people would not be presumed to be included on intestate succession. So on intestate succession, the presumption is if you have a spouse or adult interdependent partner, and any children you have are from that relationship, your spouse or adult interdependent partner would get everything. If you have a spouse and adult interdependent partner, and any one of your children is from a separate relationship, then it's a whole different situation. There's a presumption about how much the spouse should get, but then afterwards it's kind of meant to be split. It's a lot more of a complicated situation, but it does change the rules. Now, if you don't have a spouse or adult interdependent partner, and you don't have any children, then the presumption is it goes back to your parents. And maybe that's not what you would want in that circumstance either. And if your parents are there, then it presumes it goes to your siblings. And that can make for very complicated estates. I had one estate where unfortunately the fellow, we had some intestacy issues with the estate, and he didn't have a spouse or adult interdependent partner, and he didn't have any children, and his parents had predeceased him. So now we're dealing with his uncles and aunts. Well, or then it goes up to the grandparents. They have, of course, predeceased. So now we're dealing with uncles and aunts and cousins. And some of these people came from very large families, and it was a very, very complicated estate because we've got families with 8 children who are inheriting, and that made things very, very complicated for the administrator to deal with. Also, if you have anyone who's inheriting under the age of 18, all of their money has to go to the public trustee's office. There's no option about that. And ultimately, you don't have any time to do any planning, any tax considerations that may need to be considered. You can only consider that, hope your executor considers those things properly after your death. You may have undeserving family members who would inherit. Maybe you never wanted anything to go to your brother John. Well, if you die without a will, there's a chance that it does go to your brother John, regardless of what you wanted. Now, ultimately, at the end of the day, if you cannot find any known heirs and there's no creditors to claim the estate, the assets can end up going to the government, but that's not what happens automatically. And there's a number of steps that have to go through before that, but that can be the ultimate resolution is, okay, if we don't know at all, then it all ends up with the government. All right, so then we talk about how you make a will. So will's a pretty important document. How do we make it? Well, it must be in writing and it must be signed by the person giving the will. So that's the testator. Now from there, there's a couple more circumstances. There's 2 main types of wills. The first one is what we call a holographic will. That means a will entirely in the testator's own hand, signed and dated. And when I say entirely in their own hand, it has to be entirely. No part is typed. No part is written by someone else. That means they have to handwrite or print out the whole content of their will. And then they can sign it, and ideally date it. It's not an absolute requirement, but it really helps to have things dated. And that can be a valid will. But the far more common type of will is a formal will. So that's the one that you would do at a law office. So if you were coming to see me, or you're coming to see any of my colleagues who are doing presentations this week, you would probably do a formal will. And that means it would be typed. You would do a will, you would give your instructions to the lawyer would type up a formal will, you'd review it together, and then ultimately it would be assigned in front of 2 witnesses. Because when it's a formal will, when the will is not in the testator's own hand, there must be 2 witnesses present. And they shouldn't be people who inherit under the will. And they shouldn't be the spouse or adult independent partner of people who inherit under the will. Because if you do that, then any gifts given to those people are automatically revoked. Because for obvious good reasons, the rules are that someone who's going to inherit under the will shouldn't witness the will. We want neutral third parties witnessing the will, just to protect the integrity of the testator and the document itself. All right, so what does the will do? Well, it distributes the estate. Well, what is your estate? And your estate at its most basic level is the assets in solely your own name that you own at the date of your death, and any assets that don't have named beneficiaries on them. Then that estate is distributed either according to the terms of your will or according to intestate succession rules if you have no will, or if you have a holographic will where you have some problems and maybe didn't deal with the whole of your estate, you could have a mix where some of the will is distributed some of the estate is distributed according to the terms of the will, but you have what's called a partial intestacy, where part of it's distributed according to intestate succession provisions. All right, so let's talk about what's included in the estate. So what is included in the estate? Any property that is in your own name. So that can include things like real property. So real property is land. If you own the house and you were the sole person on title, then typically that's going to fall into the estate. If you have any mines and minerals rights and you're the sole name on there, it's going to go into your estate. If you own property together with someone else, but you own it as either tenants in common, or it says as to an undivided 1/2 interest, or it doesn't specify that it's joint tenants, then typically that's assets that are going to fall into your estate. Bank accounts in only your own name. If it's solely in your name and you don't have a joint owner on the account, that falls into your estate. Shares or investments, again, so long as they're not jointly held, if they're in only your name, they form part of your estate to be distributed under the will. Vehicles that are registered only in your own name, that forms part of your estate as well. And then also all of your personal effects and goods. Now, what can fall out of your estate? Well, typically it's jointly held property, but you're going to see an asterisk there and on the next page as well, because this one's a bit of a complicated situation. If we have jointly held property where we have both partners in a relationship on title to a property, this presumption is going to say, okay, yeah, joint tenancy, right of survivorship goes to them. Now, you do have to own the property as joint tenants for that to work. And otherwise, we do have property falling into the estate. But so long as we've got joint tenancy on it, that works well. Now, where you have an adult child and a parent, that gets considerably more complicated. If you own property together with an adult child and a parent, we start looking at a lot of different fact scenarios to say, well, is this intended to be part of the estate or not part of the estate? And that can end up being a very fact-specific scenario. So it's hard to say exactly what happens there. Also, if you have assets that have living beneficiaries, where you can name beneficiaries, so things like RSPs, TFSAs, insurance policies, pensions, things like that. So the assets not in the estate, jointly owned property, again, subject to that big caveat about joint owners and the complicated issues surrounding that. Jointly held accounts. So again, typically husband and wife or two partners in a relationship, they each have a joint account that's going to go to the survivor. If again, you have an adult child and a parent who have a joint account, that could be a very different situation. Lots of times parents will put one of their adult children on an account, or sometimes the bank will tell them to do this, to say, oh, well, that way your kid can help manage the account when you can't get at, if you can't get to the bank. I can see fully where that seems like a really practical solution. However, it creates a lot of legal complexities. Like if they've been named as the joint owner on the account, what was the actual intent there? So I would recommend before you name anyone jointly on property, on accounts, on anything like that, that you talk to the lawyer, because a lawyer can give you proper advice. Maybe there's additional documentation needs to confirm how the assets are meant to be owned jointly or meant to be owned together, or meant to be owned by only one of the parties' names. So if someone wanted to put their adult child on an account, I would usually have them sign, the adult child sign a declaration of trust to say, yeah, I'm going on the bank account, but I acknowledge that that's mom or dad's property and I'm not going to make any claims on it. And that way, if any of the other siblings have questions, they can say, look, we signed this. I know that the deal is I'm on the account, but it's mom and dad's, and I acknowledge that. And that sort of avoids some future issues. Now, the other sort of assets that can fall outside the estate are pensions, RSPs, RIFs, insurance policies, TFSAs, anything like that, where there is a named beneficiary who is alive. If there's a named beneficiary who is alive, then those assets go directly to that person upon death. So the named so the assets go directly to the named beneficiary when the testator died, regardless of what other instructions there are in the will. Now, there's ways to revoke those beneficiary designations in a will. Now, you would only want to do that with proper legal advice. My recommendation tends to be to people to say, change your beneficiary designations on those documents directly at the source. Don't try and just do it through the will. Go to the source and say, okay, pension, I'm going to put the correct name on it. RSP, I'm putting the correct name on it. TFSA, I'm putting the correct name on it. Because there's all sorts of things. And also there's different ways, especially on things like a TFSA and RSPs and RIFs, that you can be named as a beneficiary or a successor holder, and they have different tax impacts. So you really want to make sure those are done correctly. Now, if the beneficiary you have named is deceased and there's no alternate beneficiaries named, then those assets can in fact fall into the estate. All right, so I said at the beginning, one of the two important things that a will does is that number one, it appoints a personal representative, and number two, it distributes the estate. So let's talk about what a personal representative is. Personal representative is a person named in your will who's going to administer the estate. And at the basic level, that means they have the duties to collect, protect, and distribute the estate. They also may be the person who's administering any trusts in your will. Sometimes they're called an executor or an executrix in the will. Now, in the event that you die intestate and you don't have a will, then that is the person named by the court to be in charge of your estate on intestacy. They still have all of the same roles and responsibilities that a personal representative or testate or executor named in a will would have, and they are sometimes called an administrator or an administratrix in that position. So we said earlier that probate is when you're proving the will to be valid in court, and then you get a grant of probate from the court. Well, if there is no will, you cannot get a grant of probate because there's no will to be proved valid. So what we would get instead is called a grant of administration, and that's why they're called administrators or administratrixes. All right, so when you're thinking about who should be the personal representative, what do you need to think about? Well, the most important thing is to think about someone who is trustworthy and responsible. There is no need for your executor to have any specialized background in estates. They don't need to be an accountant. They don't need to be a lawyer. Sometimes people ask me that and they say, well, I don't know those people. Say, well, that's not necessary. We have had some fantastic executors who were school teachers or administrators or administrative assistants or anything like that. What you need is someone who is responsible and organized. Most people will appoint a spouse or partner. Often that makes a good choice because they're the person who knows the most about your financial assets to begin with. Sometimes we're appointing adult children, sometimes siblings, sometimes friends, but it really depends on your personal circumstances. It's not a situation where you say, well, who does everyone else appoint? No, you need to make that decision based off of your personal circumstances and the decisions that make the most sense for your estate. Who is the person you trust to do this? In a circumstance where you have a large estate or it's very complicated or there's significant family tensions, sometimes we're involving trust companies, and basically all of the major banks have their own trust companies, so there's always ones available, but they do tend to prefer high net worth estates, and there can be some frustrations in dealing with them, but they are very useful in circumstances, especially where it's a complicated estate because they are estate specialists, or where there's a lot of family tension, and so having a third party manage the estate can be a really good idea in those sorts of circumstances. The most important thing that you need to think about when you're choosing an executor is that they are trustworthy and willing to act. If the person doesn't want to be the executor, it doesn't matter how good they're going to be at it. You shouldn't appoint them because they don't want to do it. An executor can always renounce, so you need to think about that. You want to make sure that the person you're naming is willing to do the job you're asking them to do. So at a broader level, what are the responsibilities of the personal representative? Well, first off, they have the responsibility to collect and protect the assets of the estate. So first off, they've got to go to the banks and figure out what accounts are there, what assets do they have. They also have to figure out what the debts are. So they've got to go through, do we owe is there a TELUS bill? Is there a Bell bill? Is it NMAX or EPCOR? What bills have to be paid on behalf of the estate? They have to get the grant of administration or probate. They have to put the assets into the estate's name. They've got ongoing control and responsibility for the assets. So that can include things like making sure that the taxes get filed and paid. That can include things like making sure the house insurance is valid, but also is the lawn being mowed? Is the snow being shoveled? Are we going to get any fines from the city because these things haven't been properly dealt with? And they also have to deal with any and all ongoing legal claims and issues regarding the estate, and those can delay ultimately distributing or finalizing an estate. Nextly, we have distributing the assets of the estate. Well, once we've collected all the assets and figured out all the debts were, the executor or personal representative has to pay those debts and make sure that all of the debts get paid before any money goes to anyone else. They've got to make sure the taxes have been filed and paid and the accountant has been paid. They have to determine what assets go to whom. They have to make sure that they're carrying out all of the instructions regarding distribution in the will to the extent possible. And then they have a duty to account to residuary beneficiaries of the estate. So not all of the beneficiaries have the right of accounting, only those who are residuary beneficiaries. If what the will says is you get a teacup, you get a teacup, and you don't get any further information about the estate. They also might have the duty to administer any trusts on an ongoing basis on behalf of the estate. So there's quite a lot that the personal representative has to do. But, and this is where I said before, your personal representative can always refuse to act, or sometimes they can't act. Maybe they've lost the ability to make decisions before your death. So what do we do in a circumstance if the personal representative either resigns or cannot act? Well, when you're seeing a lawyer to write a will, one of the things the lawyer should be talking to you about is alternatives. I don't like to write a will with only one person named as an executor. I always want to have either two executors or an executor and a backup and an alternative, maybe two or three backups, depending on the circumstances. You really don't want to risk having a problem with your estate just because your executor becomes unavailable for whatever reason. You can also put in a will the power to appoint an alternate executor. So you can say, okay, well, and again, this only really is best done in a will where you've got a lawyer who can make sure the wording is correct to say, okay, trustee, you don't want to be the will, you've got to appoint your successor. Or executor, you don't want to do this, you've got to appoint a successor. Ultimately, there's no one, if the people named in the will cannot or will not act, or they all renounce their role, we go back to the Estate Administration Act, we go down that list of priorities. Now, it's a little different when there's a will in place. So firstly, you'd have your residuary beneficiaries. They'd have a power to potentially either act as executors, or they have the power to appoint someone to act for them. So there's a variety of different options. But you don't want to get there because that means you're giving up the control to make sure that your estate is managed the way you would like to have your estate managed. So you always want to give all those alternates to make sure, just in case, that we don't get to having to go to the Estate Administration Act and review the priority list. All right, one of the things that you can also do in a will is caring for your children. In a will, you can name a guardian for any minor children in the event of your death. Now, this isn't quite the same as naming an executor. Because you have minor children involved, the court always retains the ultimate decision-making authority regarding care of minor children. And so if a guardian is named in a will and then they have, for whatever reason, become unsuitable, there can be challenges against that. The court does its best to give deference to the authority, to the wishes of the parents, but their overriding concern in making sure that the children are well cared for will override the wishes of the parents if the guardians named are no longer appropriate. If you don't have guardians named for a minor child in your court, in your will, what can happen? Well, we can end up in a complicated situation where we've got lots of different family members making applications to the court, wanting to be appointed, starting fights with each other. And ultimately, if you have no family members or friends who are able to step forward and take care of any minor children you have in your care, we might end up back with Alberta Social Services having to step in and make arrangements for the care of the children, which again is not ideal. You really want to think about making sure that you are naming people who are good to make the decisions and act as guardians on behalf of your children, and making sure that you've got, like with the personal representative, alternatives named. If this person can't do it, who's the backup? Who's the backup? Especially if you have very young children, where it's possible that any of the guardians may not be able to take care of the children for the whole length until their majority. All right, so the next thing we do in the estate is distribution of the estate. Well, what can you do with your estate? Well, you can give gifts to friends, to family members, to charity. But before you do that, you need to think about who has a claim on your estate and who are the people you have a duty to and a duty to take care of under the Wills and Succession Act. So the people who have a potential claim on your estate, or to whom you have a duty to make sure they're properly cared for, is roughly the following. So your spouse or adult interdependent partner, although you can have a circumstance where you have both a spouse and an adult interdependent partner, and that can be quite technical and complicated. And then we have your children. Well, there's 3 times under Alberta law where a parent has a legal responsibility to their children. So first, when the child is under the age of 18 years, they have a legal right to be supported by their parents' estate. Also, potentially, if you have children between the age of 18 and 22 years who are attending post-secondary on a full-time basis, they may also have a similar right to be supported by their parents' estate. And then if you have any adult children who are unable to earn a livelihood by reason of mental or physical disability, they also have the right to proper maintenance and support from your estate. And so you want to think about and give consideration to these people who have a legal right to bring claims against your estate in managing your estate and in drafting your will. who needs to be taken care of, who are the priorities, and you need to understand who might be able to come and claim against your estate to try and challenge it, or challenge any gifts given in your will. All right, then we talk about what we would do in a will. Well, types of gifts that we give. So I've broken this down to some rough categories, but firstly, we have specific gifts. So gifts of, let's say, personal property, a specific item. I would like to give to my cousin Rebecca this china vase. I've identified the china vase, that's a specific gift I'm giving her. I can also give an item like a car. I could say to my nephew Robbie, I am giving my red Corvette if I have one. Those are specific items that are specifically named. You could give a specific bank account as well to say, okay, I would like to give my bank account, this account number at this bank to one of my grandchildren, or to a specific grandchild, and then you would name them. You also have kind of more general gifts. Lots of people will give gifts of money. Say, okay, on my death, I would like to give $10,000 to each of my grandchildren. And then we'd have a trust if the grandchildren are under the age of 18. But we can give just general amounts of money. Or maybe you want to give money to charities. So lots of people do it this way. They'll say, okay, I would like to give $20,000 to this charity of my choice. Or I would like to divide up this amount of money between these 3 charities. There's lots of different options for how you can do it. Once you've given away all of those specific gifts, including specific gifts of land, specific gifts of items, specific gifts of money, then we have the residuary gifts. So everything that's left over after the debts are paid, after the gifts are given, after all the expenses are paid for, then the estate will often go to certain individuals or a group. This sometimes is the biggest gift that you're giving in the will is the residue, but sometimes not. It really depends on what's happened. And this is actually the type of gift that you need to see in every sort of will. Every will should have a residuary clause or a residue clause saying, well, once I've given away everything else, what happens to the gift? Or once I've given away everything, the things I want to specifically give away, what happens to the rest? And remember, we talked about holographic will. So people who write their own will wholly in their own hand. Lots of times this is the thing missing from those wills is a gift of a residue. So people will try and give away every single item that they own. And that's not actually a really good way to write a will. And the reason for that is those are assets you own right now, but that could all change. What if you switch banks? What if you do other things? Like, what if you no longer have that car? Is it your intention to give someone the actual item or the value from the item? These are questions you would have with your lawyer. But at the end of the day, giving away every specific item that you have isn't a really good way to write a will because you don't know exactly what you're going to own at the date of your death or who's going to still be alive at the date of your death. And so maybe you were planning on giving, $20,000 to your friend Bob, but he died before you. So you gave away everything else, but we still have this $20,000. Well, that's for the residue. If you don't have a residue clause, then you'll have what we call a partial intestacy. So even though you had a will, some of the gifts are still going as per intestacy because we didn't have that residue clause to catch everything left over in the estate at the end. Now, when we're distributing an estate, we have certain priorities. And this also matches how we draft the will. So first off, we've got to make sure the debts are paid. Funeral and testamentary expenses, the taxes, legally enforceable debts, claims against the estate, executor compensation, executor costs, all of those sorts of things. Then we would give away specific gifts, all of those specific items, specific things of land, specific amounts of money. And then at the end, we give away the residue once we've determined how much is actually left for that residue. Now, there are other things you need to consider. What if your beneficiaries die before you? Just like with the personal representative and needing alternates, sometimes we want to have alternate beneficiaries. What if one of your children dies before you? Should their share go over to their children? Sometimes yes, sometimes no. It depends on the circumstances. Sometimes it depends on the type of gift you're giving. So we will have wills where one specific gift will go, well, this goes to my children in equal shares or all to the survivor, but another type of gift would go down to grandchildren or great-grandchildren. It really just depends on the type of gift being given and what that person's intentions are. We also have something called a family disaster clause or a total disaster clause that we often put in. Sometimes you run into situations where a family might all die at the same time. Maybe they're on vacation, maybe they're celebrating something, maybe there was a plane crash. I don't know, but it's a good idea to plan for what happens if all of the people I intend to leave my gifts to aren't there at the end of the day. What should happen if I wanted to leave everything to my kids and they're not there? What should happen with the rest of my estate at that point? And that's one of the things you want to consider when you're thinking about what to put in your will. Now, a little bit more about gifts of personal property. So personal property, we're often talking about things like household goods and personal effects. This can be a little bit harder to distribute than money. And that's because if I've got $100 to distribute and I've got 2 beneficiaries, I could say $100 equally to these 2 people. Great, everyone gets 50, fair is fair, that's how it goes. You usually don't have 2 of everything to distribute, or if you do, you've got 3 beneficiaries. And sometimes we can see big fights over the things because they have certain emotional or sentimental or family or historic value that cannot be replicated by money. So it's a good idea for you to think about those things in your own home and in your life and make a list to say, okay, well, to whom should these things go? To help your executor or personal representative out so that they know how to distribute these things and where these things should go. But you don't want to make that plan too complicated. Sometimes we'll have people say, okay, well, we want, all of the beneficiaries to come in and these people choose theirs and these people choose that. And that can be a perfectly reasonable thing to do, but we just don't want to make a plan for distributing household goods and personal effects to owners on your executor or personal representative. All right, so I said we're going to briefly cover taxes. Again, I'm not an accountant or a tax lawyer. We've got a full presentation on taxes coming up later on this week, I believe on Thursday, but just at a brief overview so that you understand a couple of things when you're considering your estate and how much money you might have in your estate at the end of the day, is the way that taxes work for an estate is that you are deemed to have sold all of your assets immediately prior to death. Now that means that any capital gains you have to pay, any unpaid income tax you have to pay, that all has to be paid by your estate before we distribute any other assets. So taxes on capital gains and investments need to be paid on all property, on all investments, unless there's rollovers available. One of the things that surprises lots of people, RSPs and RIFs, pension payouts, if those had named beneficiaries, those assets go to the named beneficiaries outside of the estate, like we talked about, but the taxes are paid inside the estate. And that sometimes is not what people have intended or thought about, because there could be big tax implications on those items, especially when people die, when they are relatively young and haven't had the opportunity to start taking their pension or start taking their RSPs yet. Now, it depends on to whom the people are named. So RSPs and RIFs and pension payouts will often see named to spouse or adult and independent partners, and then there's a potential rollover available so that the taxes don't need to be paid because they're not being cashed out. It's going out to that person and it's going to be included in their RSP or their RIF or their LIF, or setting up into a LIF for them. And so because they haven't been cashed out yet, their taxes aren't due. But again, this is where you want to make sure that you're talking to a lawyer, you're talking to an accountant, so you understand properly how these things might work. There are also some exemptions available. So there's a personal residence exemption. So that means you typically don't pay capital gains tax on your principal residence. Now, you can only have one principal residence in a year, and there are various different rules that apply. So we always want to make sure we talk to the accountants about making sure that that's dealt with properly. Sometimes there are small business exemptions for closely held Canadian corporations, and again, you want to work with the accountant to make sure that those are being properly claimed. Sometimes if people have farm or fisheries properties, there's certain exemptions that can be claimed on the capital gains there. It is very important to get proper accounting advice, both for yourself before you deal with your will, especially if you have any of these complicated matters to deal with in your will, but also for your executor in dealing with your estate to make sure that all the exemptions are properly maintained and taken when necessary. So when you're thinking about your personal representative, we want to think about all the work they have to do. And one of the things you need to think about is you need someone who's going to be able to file all the taxes, because there's a lot of tax work that has to be done with the states. So your personal representative is going to need to for sure file what's called a terminal T1 return. And so that is the return that covers from January 1st to the date of death in the year of your death. Now, if you die before October 1st, then that would be due April 30th of the next year, like a regular T1 return. If you die after October 1st, then typically it's due within 6 months of your date of death. But your personal representative may also have to file what's called a T3 or trust return. So remember how I said terminal T1, January 1st to the date of your death? Well, what if your assets keep increasing in value? What if we can't get everything cashed out right away and there's more income tax after your death? Well, that's on the T3 return, and that's going to be filed on every year until we're able to get until your state stops receiving income. All right, so one of the things that we address in wills is trusts. We will often put in trusts and wills to deal with a couple of different circumstances. So a trust is established where you are providing assets to one person who is the trustee to hold for the benefit of the third person who is a beneficiary of the trust. Now, we're going to talk about testamentary trusts, which are the trusts that are usually created in a will or created upon death. Inter vivos trust is another type of trust that's set up while you are alive, but because that doesn't really deal with wills, we're not going to cover that in this presentation. One important thing to know is that actually your whole will is a trust, because you appoint your personal representative or executor, and then you give them certain assets on the trust set out in the will, that they're going to do what the will says. And then they're going to distribute it in accordance with the term. You're just going to distribute your estate in accordance with the terms of your will. However, we've sometimes set up other additional and specific trusts and wills, both for adults and for children. So with children, we particularly give consideration to that people under the age of 18 years cannot directly receive gifts. If we are trying to give something to a person under the age of 18 and there's not a trustee named in the will, then their gift will be given to the public trustee's office to have control of until they're at least 18 years of age. Now, you may not want everyone to receive all of their gift exactly at age 18. So you might want to think about trusts that go beyond age 18, which you can certainly do. You can choose a trust that so that your beneficiaries won't get the money till they're a little older, maybe 21, maybe 25, maybe 27. It depends on what you're thinking of. You can also do a staggered trust if it's a big trust, to say, okay, well, maybe they shouldn't get it all at one time. Maybe we give them a couple of kicks at the can at learning financial responsibility. We also want to make sure that we've got a power of encroachment in a trust. And so what that is that gives the trustee to release money early, to not just hold everything back until they're 18, but maybe they need money early for education or healthcare, or just to make sure that they're living a proper quality of life, or other good and specific reasons. Maybe you want desperately to be able to pay for, a trip once they're 16. Well, you can put that specifically in there and say, this is what my trustee is empowered to do with this money. A trustee ultimately does have the duty to account to a beneficiary for the use of the trust funds and say, okay, here's how much money came in, here's what went out. But trustees also have to file and pay taxes every year on the trust. So there is a lot of work involved with that too. Now, that's about trust for children. When we're considering adults, we're also considering that they might need trusts. Sometimes we have people who are not good with money or not good with money yet, and we want to wait till they're a little bit older before they receive their money. Maybe age 30, maybe age 35. We see this more commonly when there's really large sums involved in estates, but not exclusively. The other large area of trust that we see is where we're dealing with what we call discretionary trust. So this can be Henson Trust, this can be other types of trusts, but a discretionary trust is a trust where it's discretionary on the trustee how much and when they release money. Now, we will often use this for adults who have developmental disabilities because it doesn't have the same impact on AISH funding if it's properly set up and properly managed, so that a person who has developmental disabilities who is on AISH will not lose their AISH simply because they inherit. Under the AISH rules, you can only have up to $100,000 of non-exempt assets. And so inheritance that's not in a trust for a person on AISH can cause them to lose their AISH funding. Now, AISH funding is not just the money, it's the access to the social services that come along with that. Also, we always want to be aware of that AISH only goes to age 65, and then after that, that person can only get CPP and OAS, which is actually less money than AISH. And sometimes their needs and their healthcare needs are substantially greater at that time. And that's when we want those trusts to be funds available to make sure that they're being properly taken care of as they age. We also will use discretionary trusts for adults who have addiction issues, for whom receiving a large sum of money or any sum of money in a lump sum is a significant risk and could lead to potential illness or death, especially because of addiction issues. And so sometimes we'll use trusts to properly manage that as well and to try and limit that impact on a person. All right, so let's talk about some quick general wills questions that I commonly come across. One of the most common ones is, does marriage or divorce revoke a will? So neither of them will revoke a will, but divorce can revoke gifts and appointments of people in a will. So if you get divorced, that typically revokes the appointment of your former spouse as a personal representative, and it will typically revoke any gifts given to them. However, by far the best plan if you have gone through a breakdown of your relationship is to go and get a new will done. Don't rely on the fact that, oh, this should be revoked upon our divorce. Do a new will, because you've got new things to consider now that that relationship is over. What if your spouse predeceases you? So lots of people will say, well, I'm just going to leave everything to my spouse. But what if they predecease you? That's why it's important to have alternatives alternative personal representatives, alternative beneficiaries, to make sure that you're covering what happens if you die after your spouse and you can't leave everything to them. What do you do if you no longer have an item that was given in your will? So it depends a little bit on the type of item, but broadly, if a will says, I give to my Aunt Sally my crystal bell, and this person no longer has a crystal bell at the date of their death, then that gift is said to have a deemed. And so you can't give something you don't have. It's a little bit different with financial gifts. It depends a little bit on the circumstances, but that's broadly how it's typically dealt with. And then what do you do if someone that you're giving specific gift to predeceases? Well, if you haven't updated your will to put in new beneficiaries, then if the person who was supposed to get the gift dies before you, then that gift just forms part of the residue. You can't give it to someone, you can't just presume a different beneficiary. If that person who's supposed to receive it in the will isn't there, that gift falls into the residue and forms part of the residue of the estate and is distributed in that manner. All right, and then what do you do if you change your mind about your will? Well, so long as you still have capacity, so you have to have the legal capacity to be able to execute a will, then there are a couple of different options. The best one, and the one I recommend, is to make a new will. When you go and see a lawyer, one of the things that your will says, well, this is the last will of blah, blah, blah. I revoke all prior wills and codicils. And then you start fresh, you do a whole new will. That's the best thing to do if you change your mind about the will. And ideally, you go see a lawyer and you see about making changes to your will, or doing what's called a codicil, which is a document that amends a will. You can destroy your will, leaving you intestate. That's not an ideal solution. Again, you really want to see about getting a replacement document made or an amending document made. And then also you can technically sign a declaration declaring your intent to revoke your prior will, which would be a revocation. But again, the best thing to do is to try and go see a lawyer and get a new will done or get a codicil done to take out the bits of your will that you don't like anymore. That's by far the best plan. All right, so hopefully that has been helpful. Now we have some time for some questions, Matt, if any of them have come in.
Yeah, so first of all, thank you for that. Very informative. Really appreciate you going through that. I know for some of the folks, there are a lot of questions here. So we will go through as many as we can, and I'll try and keep them relatively generic. But I'll just answer a couple of things that repeatedly came up in the question box before we get started. Yes, certainly. Thank you for bearing with us. We know that there was a gray box that was blocking some of the slides. Didn't seem to take away too much information, but either way, we will plan on providing you with this slide deck within the next day or so after this session wraps up, so you won't miss any of the information. And then second, once again, just to reiterate that when we do post these virtual sessions that we are recording, they will be available on the ECF website www.ecf.ca. And finally, just a very quick correction. I mentioned that there were 9 Wills Week sessions earlier in my introduction. That's faulty information on my end. Actually, 14 throughout the week this week. So lots of information, plenty of great presenters, including Michelle Coleman from MNP, who will be doing a tax-specific session on Thursday morning. So if that is of interest to you, still time to register for that virtual session on our website. So without further ado, I'll jump in. Lots of questions. Like I said, we may not get to all of them. I may be a little bit picky just to make sure that these are somewhat generic, but keep in mind there are other options for you to attend sessions this week and the Q&A on Friday. So starting with a couple of somewhat simple ones, there was a few questions around holographic wills. And I know you mentioned that a little bit earlier in the presentation. So maybe I'll just jump into a couple of those questions. One question specifically, if you are creating a holographic will it need a witness?
So no, if it is a fully correct holographic will, so there's a will entirely in your own hand, so you have to take a pen and paper and write the whole thing out, then it does not technically require a witness. However, in order to probate that will, we will require what's called an affidavit of handwriting. So someone who's not inheriting under the will, is not a spouse, is not an adult interdependent partner of someone in the will, has to swear to say that in fact is your handwriting. If you're doing a holographic will, it is not an absolute requirement that you date it, but please do. It makes it so much easier.
Thank you very much for that. I know I had another one here. Again, like I said, lots of questions around all sorts of will. So I'm going to assume that this question means holographic will based on how they wrote it. And I assume that the answer should be relatively straightforward given what you just said. But is the will written on paper valid? So my guess is they mean a holographic handwritten will.
So again, it can be a proper a valid will if you write entirely in your own hand. If you print off any part of it, if you use a will kit, then you technically require 2 witnesses because that's a formal will. Only the documents that are entirely in your own hand, and by that we mean pen and ink, write it out on a piece of paper, sign it, that is a valid will. Like I said, there are lots of issues with doing it that way, but that is technically a valid will. If there's any part that is printed, any part that comes from typed or written by someone else, then that's not a holographic will anymore.
Perfect. Thank you. So I'm going to go up here. This question came in a couple of times around beneficiaries and especially around the personal representative. Can a representative also be named as a beneficiary?
Absolutely, and that's very common. So like I said, lots of times people appoint a spouse or adult independent partner or adult child to be their personal representative, and they would also be a beneficiary under the will. There's no conflict with doing that. It's quite common.
Perfect. Thank you. A few coming up here. So moving into sort of the executor piece, and we touched on fees a little bit, but there's a question here that says, does the executor get paid, and does the power of attorney get paid for holding that role?
So yes, both of the, well, do they get paid depends on the circumstances. They both have the right to make a claim for compensation for the work that they have done. And then that's either approved by the residuary beneficiaries of the estate or filing that by a judge. You can, however, in a will, put in specific terms or in a personal directive that says, I want my executor to be paid X dollars or X percentage or so much for the work that they've done. Great,
thank you. There were a couple of questions around, which again, I know that you touched on, but maybe we'll jump back into that just a little bit here. Executor services. A couple of people asked if I do not have someone that I know or trust as my executor, are there any options outside of maybe the major banks, like you pointed out? Are there any other options for executor services?
This one's a little bit more complicated because there are some trust companies that are not necessarily attached to major banks. Really, I would talk to your accountant, your investment people, because they might have different people. There are sometimes retired lawyers or some accountants that will act as executors as well. But by and large, there's not a lot of other good alternatives that I am aware of for executors. Ideally, you want to find someone in your sphere. Maybe they don't have to be someone really close friend or a family member, but you have to see if there's someone who's willing to do this to help you out.
Great. Okay, so I've got a couple questions here around making some changes to the executors on a existing will already. We have a will and we want to change our executors. We have two and want to change both of them. Can we change them ourselves, or do they need to be witnessed by a notary or a lawyer?
So they don't have to be witnessed by a notary or a lawyer. And what I don't know from this question is what type of will is it? So if this is a formal will, then I would tell you, you need to do that by doing a codicil, which is a document where you say, I am going to specifically change this type of will. And then that still should be witnessed by two witnesses. It doesn't have to be a lawyer and or a notary, but ideally it should be witnessed by two witnesses.
Great. Hopefully that answers their question. I'm going to get into a couple of other things around gifts, but there's a question that comes up around probate. Do all wills need to go to probate, or only if property is involved in an estate?
So all wills do not need to go to probate, but it's not the question as to whether they go to probate or not does not solely depend on if there's property involved. Now, if there is property involved and it's solely in the deceased's name, it almost always has to go to probate because land house won't accept anything other than a court order. However, sometimes when there's not property involved, the values of the money for the banks are too high to release without a grant of probate. So it does depend on the nature of the assets and what we can get the banks to release. The banks used to be willing to sort of release up to $30,000. I wouldn't say that that's true anymore. I have had clients be told that they have to probate the estate to get the $2,500 death benefit from CPP dealt with. So it really depends on what the banks are comfortable with. Now, if you have a lot of assets that are joint, so if it's spouse or partner, one of you dies, everything is joint, we have the will there, but often everything will flow automatically. We've got named beneficiaries, we've got jointly held assets. Well, maybe everything flows without us ever needing to get a grant of probate. And that would be ideal in a situation where we have a spouse or partner, especially if it's a first marriage or first serious relationship, because that will make things nice and easy.
Okay, great. And someone else had asked, and you kind of answered it here, but maybe just to drive the point home, why is probate necessary? If there's no property or anything like that, why is it necessary if someone's gone through the process of setting up the will, going through the assets with the lawyer, all that sort of fun stuff? But you kind of did touch on some of that, but.
So when it's necessary is when you have assets in the estate that you're going to need a court order to deal with. So land is only in the person's name, what the banks are going to deal with. The banks would tell you that there is risk to them releasing money to someone who is not named on an account. And they don't want to have someone come back and sue them and say, you should have never given this money to this person. This was not a proper will. So when you go to court and get the grant of probate, then the bank can say, well, this is a court order of the court. I was simply following the court order. We don't have liability for this. Go after the bad person who took the money. That's sort of the essence of it. So we've got to determine the assets can they be released without the court order or not?
Okay, great. So there was a couple questions here too around joint assets. So I'm just going to find those really quick again here. Oh, this one comes up quite often given our close relationship with the province of British Columbia. I own vacation property in BC. Does an Alberta will cover that, or do I need a separate BC will to cover what to do with that property?
So you don't necessarily have to have a separate will. A will done in Alberta can cover BC property. A BC will can cover Alberta property. Wills law is very, very old. And so a will done in one province will cover almost every other province in Alberta and Canada. However, you might need to probate the will in both Alberta and BC, or typically what you would do is you'd probate in one province and then basically get a grant of double probate in the other province.
Right.
And so because you only have one original will and you've already given that to the court. But sometimes it does make sense to have a separate will in a separate province, depending on the nature of your circumstances and the nature of the assets involved. Like sometimes it makes sense to say, have person managing the property in BC who's in BC, and have the person managing the property in Alberta who's in Alberta, especially because there are different rules about who can make claims against an estate in BC versus Alberta.
Okay, thank you. A couple of questions around joint accounts and joint property. If I have a joint bank account with, say, a parent, do I have access to the account to pay bills, etc., after death, so long as I provide a death certificate to the bank?
So typically, a jointly owned bank account is the surviving owner would still have access to it after death. Now, I have had a couple of situations, not in the parent-child situation, but spousal, where people have been told by various different banks or banking officials that no, you no longer have access to your joint accounts. That is incorrect. But that doesn't necessarily mean that that account is yours, especially in an adult child and a parent situation. There can be very different interpretations of how those assets are actually meant to be owned. And so you can't presume that that is now your asset, unless we've done the paperwork to say, yes, it is, or no, it isn't. And it's best to do that while your parent is alive.
Right. Okay, great. So here's a question around benefit to name. Is there any benefit to naming the estate as the beneficiary for an RSP, a pension, insurance, etc.?
Well, the benefit, if you have no named beneficiary, the presumption is it does fall into the estate. And sometimes it makes sense to name that. One of the reasons might be is, so let's say this is a circumstance where you don't have a spouse or adult interdependent partner, but you have 3 children. And you might say, oh, well, I'm going to name all 3 kids on my beneficiaries, on my RSPs. That's great. Money will go directly to them. Doesn't really matter about the taxes. We'll deal with that later on. Okay. But one of the problems with doing that is if one of those children happens to predecease you, then that assets get split between the 2 surviving children. It wouldn't go over to grandchildren. We can set that up really well in a will. It's very hard to do that with beneficiary designations. So that's one of the things you want to consider, and why some people might say it's better to name it to an estate, because also setting up trusts, if we wanted to go to someone who was going to be held in trust, far easier to do in a will, very complicated to do through the beneficiary process.
Okay, here, speaking of beneficiaries and where we move with this, if I have a house and 4 children are equal beneficiaries, do the 4 children go on land title? What happens if 1 or more do not want to sell the house? What is the best way to manage a house in the estate?
So typically what would happen is when you die, the executor takes control of the house. And it depends a little bit on what other assets there are involved, but the house wouldn't necessarily go into all of the beneficiaries' names. What most often happens is that we liquidate all of the assets in the estate and then distribute in cash. Now, if one of the beneficiaries would like to buy the house, or one or more of them would like to buy, they certainly can buy the house from the estate using their assets, using their share of the estate, and potentially getting a mortgage to pay for the difference. But you can't force someone to own a house with other people. Even ultimately, if you are, two people do own a property together, there is ultimately a way through the Law of Property Act to say, I don't want to own this house with you anymore. Either buy me out, or I'm going to go to court and we're going to forcibly sell the property.
Okay, great. So we're talking about leaving gifts to both people and potentially charities, anybody else. Are these gifts taxable?
So the gifts are not taxable in the hands of the beneficiary. The tax is paid in the estate before the gifts are given. And so when the beneficiary receives the gifts, they are typically without tax on them. However, it can be a little bit difficult in a circumstance if you're getting shares or something from an estate. There can be a little bit difference in how those items are going to be dealt with. But if it's just an amount of money, it's on a post-tax basis.
Great. Rolling over into a capital gains question here. If an adult is on the parent's property deed, but not the primary residence, or sorry, if an adult child is on parent's property deed, but not the primary residence, would they pay capital gains for that property?
There's a risk that they would have to pay capital gains for that, because once you're on title, CRA assumes that you own a 1/3 interest. That is why if you're going to go on property joint in any sort of name with your parent, we want to have a declaration of trust done to say, well, is this intended to be your property as well? Are you intended to get it when your parents die? Or is the presumption you're just there to help manage it? Mom and dad, this still remains all yours, and then you can use a declaration of trust to address those tax concerns.
Okay, thank you. This is around registered plans and beneficiaries for RRSPs, TFSAs, unregistered investment accounts. We know we can name a beneficiary, but does that beneficiary need to be a person? Can it be something like a charity?
You could absolutely name a charity on those. But you just want to think about the tax implications. Now, if you name a charity, the tax credit should come back to the estate, but you just want to make sure that you understand that that means those assets are now not going to anyone else you've named in your will, and they're going fully outside of the estate to the entity named.
Thank you. And I use that question to selfishly roll into this one. Why would I set up or donate to an endowment fund that pays interest to a charity versus donating the entire lump sum and letting the beneficiary or that charity decide how to manage the assets? Now, I'll quickly jump into this and say it's completely a personal decision. How you decide to make charitable gifts is completely up to you. Just because our business happens to be endowment, that doesn't mean that it fits with everybody who is considering leaving a charitable gift behind. What we like to talk about is that long-term effect for the ultimate outcome for that charity that you want to support. An endowment allows for generations of support to be provided to your favorite causes instead of a lump sum. But either way you decide to look at a charitable gift, again, completely up to you. We are simply one option. An endowment fund is simply one option to consider, where there are hundreds of other avenues to explore. So if you wanted to talk about your charitable interests, we're happy to have that conversation, even if ECF is not your ultimate outcome. And I will say that there is going to be another session later this week on Thursday that details all about charitable giving and your using your estate plans to support the charities that mean the most to you. And while we, ECF, may be having this conversation, by no means does that simply mean we are the be-all end-all. It's simply getting you to think about charity and how you can leave something behind if that's of interest to you. So thank you for that question. We don't get a lot of charitable questions in these conversations, so I appreciate it. A couple more here as we're kind of wrapping up on time. A few questions here. This is an interesting topic, at least to me, because it's becoming more and more prevalent, and I want to get your input on this, Anna May, as an estate professional. Is a will prepared via online platforms like Law Depot, Willful, Epilogue? Is that a legal document? And what are your thoughts around using an online will service?
So online will services are in large part no different than the fill in the blank wills that we used to find at Staples, and I think you still can find them around. Can there be some, it's all in how you fill it out, but the important thing to remember is that is not a holographic will, and it cannot be. It is a formal will, so you need to make sure that you are doing all the things to match the formal requirements of that will. You also have to be very careful in filling out the will that it means the things you think it means. I had a will done on an electronic form, and we had executors, and it was wonderful, and appointed everybody. And you know what it didn't do? It didn't distribute the estate. And so we still had an intestacy. The person who would have been intended, who was a stepfather, who would have more than likely been the person who would have been intended to receive the money, did not receive the money because he wouldn't inherit under an intestacy. Now he chose to stay on and be the executor because he felt it was most important to try and do what he could for his stepson and his stepson's estate. But you have to be careful with those because you're presuming things into it. And it's all in how you fill out the information. One of the lawyers who I think Victoria already did her presentation, didn't she?
Yes, earlier today, yes.
Victoria Jones, who's one of the lawyers, she does a lot of estate litigation law. She would tell you that those wills or the online wills, they're great for her because she can buy some new fancy shoes because they start a lot of fights. Because it's not always clear what is intended in the document. It's not always filled out to the extent that you expect it to be. It's a little bit, I said holographic wills often miss residue clauses. That often gets missed in the fill in the blank or the online will kit wills as well. So can they be legal? Yes, if filled out properly, but there are a lot of risks involved in them. And it's not the same as seeing a lawyer.
Yeah, thanks for that. I know that's becoming more and more prevalent. So just getting your insight on that is really insightful. I hope for everybody listening too. And yes, I did a photo shoot with Victoria leading up to Wills Week this year, and she was wearing some funky glasses and a really cool pair of shoes that she was very quick to point out. It was online wills or something. That ended up funding that wardrobe choice. So yes, she's always funny with some of that stuff. Just two more questions, and I apologize to everybody. There's a ton of questions in here. We tried to get to as many as possible within our time frame. I really appreciate Anna Mae's time here. We will try and get to more of these throughout the week, so don't let this be the only time you try and ask. But two quick ones. How much, and it doesn't have to be exact, of course, I'm sure it never is, but how much does it typically cost to get a will done? And I'll say your typical costs to get a will done going to you.
So everyone does a little bit differently. I have I have a bit of a menu where I say, okay, well, if I have a single person with a will, an enduring power of attorney, and personal directive, typically I'm charging somewhere between $1,100, $12,000, and $1,200 plus GST and disbursements. For a couple, we're looking at something closer to $1,400. Now, the idea there is that we can do it on a bit of a discounted rate because their wills are very, very similar. And so it's not a whole brand new will individually. I understand that that might seem like, oh, well, that's not fair to single people. It's done on the basis of what can be done more efficiently in the office. And so that's frequently one of the items. So it's about $1,400 plus GST and disbursements is what I'm currently charging. In my office, I have lawyers that charge more than that are more senior to me. I also have lawyers that charge less than that who are more junior to me. And you'll see that basically throughout many different firms. Lots of firms charge in different manners, but that for me is typically your will, enduring power of attorney, and personal directive. Currently, right now, that being said, those prices can always change in the future.
Sure. No, that's a good ballpark for people to consider when they're thinking about their planning. And just to wrap up with this last one, talking about establishing a will and going through that process, ideally, how often should someone update or create a new will or something like that? And does a will ever expire?
So a will doesn't expire in the sense that just because you did your will in 1980 and you die in 2025, it doesn't mean your will has expired. Now, your will might be out of date and no longer match your wishes, but it doesn't expire. And so even if the will is out of date, we've got to go forward with it and probate it and deal with it. Now, I don't know if you need to necessarily update your will, but you should be regularly reviewing your will at least once every few years, at least once every 3 years, or if a major life change has taken place. Did you get married? Did you start a new relationship? Did you have a child? Did you have a grandchild? Did you buy a new important piece of property? Did you start a new business? Those are times when you want to look at your will and look at your estate plan and say, does this still match what I want? Does this still reflect the reality of what I'm intending to give to my family, friends, whatever, charities, whatever the intention is? And then if the answer is yes, great, you don't need to redo your will. It's good that you took the look at it. That's all you need to do. And if the answer is no, that's when you come and see the lawyer to say, okay, let's update it because your wishes have changed and this will no longer reflects your wishes.
Awesome. Thank you. That's a lot of questions that you answered. So thanks very much. And again, I know for the people who have put answers into the Q&A, we couldn't get to everything. We certainly do appreciate the fact that you've provided some questions for us. Perhaps we use some of these to fill our Q&A session later this week on Friday morning. But I just wanted to thank all of you, and especially Anna May, for being here. Anna May, thank you very much for lending your time and expertise to this conversation. And to all of you, on behalf of ECF, we really appreciate you taking the time to spend with us this evening. And I will remind you before we log off for today, this recording will be available on our website, ecf.ca, within the next week or two. So please check back to see when our recordings will be posted. And please do take a minute or two at the end of this session to fill out the survey. Those questions and your answers are super important to make sure that we're providing a worthwhile service to the public moving forward. But beyond that, I really appreciate everybody taking the time to be here for Wills Week 2025. And we look forward to seeing many of you throughout the week this week. And feel free to drop by our website for more resources. And one last reminder, we will be sending out the slide deck, thanks to Anna May, to everybody who has registered for this session. So you will get a follow-up from us here in the next day or two. And before I shut off the Zoom, Anna May, any closing words from you?
No, I don't. Just hopefully this was all very helpful, and I hope that you all get wills done and have proper estate plans.
Awesome. Well, thank you very much. Have a great evening, everybody. Take care, and we'll talk to you soon.